Hi everyone, my name is Peter Maguire and thank you for attending the first of our free webinars on navigating Fair Work Modern Awards, positive duties and all that people stuff. We're putting these on because we already have a very complex workplace relations system, and with the biggest era of change we've ever had in employment law, um, it's becoming even more complicated. A lot of those changes have come about because corporates have done the wrong thing, and governments respond, and small businesses end up wearing a compliance burden. So we thought that we could run these sessions to give you an understanding of what the changes are, what are significant ones, what you need to do compliance-wise, and how you might be able to deal with all of this stuff going forward. So that's why we're here, and thanks for being here. So a bit about us. Ridgeline HR started in 2000, and we essentially help people in business with their people business. So that's all the compliance stuff, and we do a fair amount in the enterprise agreement making space. We work with Employment Hero in terms of a cloud-based system that links with Xero and other online financial systems. We can act as your outsourced HR manager and coach you in how to deal with people issues in a positive way, and we can help you to develop great workplaces using our positive psychology set of tools, which are under this banner of POSWork. So this stuff was evolved about 15 years ago. I decided that HR didn't work, and I started regretting calling the business HR, to be honest, because it is about people and relationships. And I was looking for something different because I really didn't think HR worked as it should. I got into the study of positive psychology, and from this, all this stuff has sprung. So the Better Workplace projects are deep dives into organisations that want to develop positive people cultures. The coaching stuff is around redesigning performance and development management processes through a coaching model. The Better Change, we use a strengths-based change management process called appreciative inquiry. And the Better Stories is about changing the language to be more positive. So for example, if you've ever been into a business where managers say that people are our greatest asset, and then you look at their policies which say people are our greatest risk, you can see what that contradiction is. So we can clean up that language and make it more positive. We also do employer value propositions for businesses, because most employers are terrible at presenting themselves to the labour market with the answer to the question about why people should work with them. And in the last couple of years, we've got into animated storytelling and explainer videos, etc., as another aid to communication. So where's all this stuff come from? And it is a perfect storm, because there's just all this stuff that came together. The first is that with any change of government, the pendulum swings the other way. And we've had the Libs in for a long time before Albanese got in. And so it's swinging further than it has for a while. And there are a few areas that the Morrison government, etc., legislated on where there are significant swings back the other way now. We have all of the stuff around gender equality and sexual harassment and domestic violence, which is right in the spotlight. And a lot of the changes are about protecting women in the workplace, and we'll deal with those in the course of the presentation. Plus, we'll have another whole webinar on the subject. The rise of mental health issues, rising workers' comp premiums, and the introduction of positive duties to eliminate psychosocial hazards is another element that is in the mix. And again, we'll cover that a little bit today, but there'll be another whole webinar on that. And then when it comes to the courts, there are two areas. One is that the decisions that are made by courts in relation to and by courts and commission in relation to employment laws and modern awards and all of that sort of stuff. Plus, there are decisions that are made and the cases that are reported around non-compliance by corporates and the fallout from them. So it's all of that stuff that has come together to make this perfect storm. Another element with all this is that there are so many jurisdictions and people rightly are confused. So, for example, if you look at a sexual harassment claim, the Fair Work Commission has for some time had the capacity to issue orders to stop sexual harassment and stop bullying. And now it has powers to deal with disputes in relation to sexual harassment with the potential for awards of compensation. But the jurisdictions haven't really worked that have been there for a while for the reason that, if a complainant just leaves, if a perpetrator leaves an organisation, then there's nobody to issue orders against, and so the cases just come to a halt, and the applicant gets no closure. So part of the reason for this is to provide a more effective means for that to happen. The Australian Human Rights Commission has powers to enforce the positive duty to eliminate sexual harassment, sexual discrimination, victimisation and gender-based behaviours from workplaces, and will be able to do inspections and initiate proceedings for breaches. Because sexual harassment is a psychosocial hazard, it also is something that's within the purview of WorkSafe, and they could prosecute that as a breach of workplace health and safety law. The Victorian Equal Opportunity and Human Rights Commission has a jurisdiction for prosecution of complaints of sexual harassment. Safe Work Australia isn't an enforcement agency, but it does set influences policy by issuing codes of practice in relation to how these issues should be addressed. And they can form a bit of a blueprint for state governments in legislating. And the Fair Work Ombudsman can investigate complaints of discrimination. With sexual harassment, they're probably more than likely to refer it to another agency. But as you can see, there's lots of different places you can go, and that's one of the reasons why one of our webinars will be on where do you go for what, who are the players and what role do they play. So here are the 7 free webinars that we're going to be running, starting with today's one, the biggest era of change in employment law ever. Then we'll do understanding the fair work system and the players, so people know who does what and where to go for what. What do these new positive duties mean for small and medium businesses? What are national employment standards, which a lot of people don't realise are not negotiable and apply to all employees? What are modern awards and how do they work? We've got a very complicated system with awards, and what we'll try to do is to give people an understanding of how they interplay with national employment standards and contracts, and also how to read and understand them. What are psychosocial hazards and how to deal with the positive duty to eliminate them, as I mentioned before, and how to deal with the positive duty to prevent sexual harassment. So they'll take us from now, 1 month through to November. Yes, we hope that people can learn from them and they make a difference. So we'll hop into the changes, and this is going to be a bit of a dump. There's a stack of stuff to get through, so I'll just motor along. So it started, and I'm doing it over 3 years, from August 2022 through to August 2025. In August 2022, Safe Work Australia released the Model Code for Managing Psychosocial Hazards at Work. And this is sort of the blueprint that states and territories then use to develop and implement legislation on the positive duty on organisations under workplace health and safety laws to deal with psychosocial hazards. Victoria was the first to start legislating, and other states have since done that, and Victoria is still finalising regulations, but probably not far away. WorkSafe were already active in that space at any rate. In December 2022, there was the positive duty to prevent sexual harassment, sexual discrimination, victimisation and gender-based behaviours, which came via the Sex Discrimination Act in response to all of the stuff that happened with the revelations about sexual harassment in the corporate world and in Parliament and so on. Gender equality and security of work are included in objects of the Fair Work. So the objects of the Fair Work essentially tell the courts and the Fair Work Commission the things they need to take into consideration when they're making decisions on matters under the Fair Work Act. And the inclusion of gender equality and security of work mean that the Commission has and the courts have to consider those things in all the decisions that they make. And we're seeing that play out in particular in the Commission in gender-based work value cases that are being run, one in aged care and another in for nurses and midwives, with probably childcare to come. New protected attributes in the Fair Work Act: breastfeeding, gender identity and intersex status. And the reality is that that means, as they're protected attributes, and people can be discriminated against them on that basis, which means that they could give rise to adverse action complaints under the Act in relation to those protected attributes. And a prohibition on pay secrecy clauses in employment contracts, which one of the reasons for introducing that is that pay secrecy clauses are particularly detrimental for women because of the fact that when there is this gender pay gap and the pay secrecy is a barrier to transparency around pay. So that's why that's been included. We saw the advertisement of jobs with below statutory award minimum wages, and yes, people still do that. They advertise a job at $25 for a casual, and the award rate is actually 28 or 29. So organisations do that can now be prosecuted for it, and if the Fair Work Ombudsman happens to see an ad like that, then they'll more than likely go in and do a full inspection on the business in relation to its compliance with employment laws and modern awards. In February, 10 days paid family and domestic violence leave for employees and employer with 15 plus employees. And remember that 10 days is for full-time, part-time and casual employees. There is no proratering for part-timers or casuals. The abolition of the Australian Building Construction Commission, the transfer of powers to the Fair Work Ombudsman. We're already seeing a rise in unreasonable behaviour in the industry. New jurisdiction at the Fair Work Commission for disputes in relation to sexual harassment, as I mentioned earlier. And the Federal Court rules that employees can be requested to work on public holidays but not required to. So that was just a clarification of an existing provision of the Fair Work Act, and is probably of most relevance to retail, hospitality and nursing industries. The Fair Work Commission changes the rules on annual shutdowns now. This was significant. It was a ridiculous decision, and it has some effects. There are three contexts. The first is that the Fair Work Act says that in relation to award fee or agreement fee provisions, that an employer can require people to take annual leave in reasonable circumstances, which in the Act includes the potential where there is a temporary shutdown of an employer's business. With respect to award-covered employees, the Act says that the award or enterprise agreements can contain rules around this. So this decision last year varied the award provisions to provide that an employer is firstly required to give people written notice of a shutdown, is then required to give individual written directions to individual employees who they want to take annual leave during the shutdown period. And then if someone doesn't have sufficient leave to cover the period, the employer can ask them to take leave without pay or to take annual leave in advance of their next year's accrual. But if the employee does not agree, then the employer is left with the options of either just paying them for the period or providing them with some work. If the award doesn't have an annual shutdown provision, and some don't, people covered under that award can't even be directed to have a shutdown. So there are different scenarios. They might call them unintended consequences, but they've made something that was fairly simple very complicated. In February 2023, new obligations for consideration and consultant and requests for flexible working arrangements and extensions to parental leave, and in both cases access to the Fair Work Commission for dispute resolution, really up the ante on consulting with employees about the requests they're making and trying to accommodate them, and then providing a jurisdiction where employees can take them if they don't get the answers that they want. And then there's a total prohibition on pay secrecy clauses with penalties for breaches. So that came into play. We had the biggest ever annual wage review decision, with the federal minimum wage increasing by 8.65% and award wages by 5.75% in July 2023. Changes to child employment and permits, which are regulated by Wage Inspectorate Victoria, and they're busily out there finding businesses that are not compliant and prosecuting and fining them. There's an increase in parental leave pay to shared entitlement of 20 weeks. The 2-week dad and partner pay was added to the 18 weeks that the primary care already got, and then added to that is that it's increasing by 2 weeks per year until it goes up to 26. There was an adjustment to the number of flexible days that partners can use on parental leave from 30 to 100. Small claims cap for underpayments is up from 20k to 100k, so that provides a low-cost jurisdiction at the Fair Work Commission that people can take claims of underpayment up to that amount. And the work value case in the aged care sector provided 15% wage increase. In August 2023, the 10 days paid family and domestic violence leave came in from businesses with less than 15 employees, and award dispute resolution clauses were varied to cover disputes about flexible working arrangements and extensions to parental leave to provide easier pathways to dispute resolution in those jurisdictions. In December, the Australian Human Rights Commission's positive duty enforcement powers took effect. And I suppose the question at the moment is whether they'll have the budget to do much, but they have the powers normally to be able to enter workplaces to conduct inspections and to prosecute for breaches of the positive duty to prevent sexual harassment, etc. There's a new Fair Work Commission jurisdiction for labour hire workers under the Same Job, Same Pay initiative, which is about employees who are hired via labour hire having the same pay and conditions as employees engaged internally by the host as direct employees, where there is an enterprise agreement in place. It doesn't have much effect on most businesses, if any, and it's really directed at the fly-in, fly-out, the big mining companies and those that replace their internal workforce with labour hire with a view to reducing operating costs. Small business redundancy exemption was modified for progressive downsizing. So if, for example, I have a business with 16 employees and I downsize to 14, then as a business with 15 plus employees, I have an obligation to pay redundancy to people. Once I get below 15, I don't. So what this is saying is if you reduce below that threshold level, then it's where you started that counts for any redundancies through to the end of the process. The limitation of fixed-term contracts to 2 successive and maximum aggregate term of 2 years, plus there's a fixed-term employment information statement that has to be issued to people. In January of this year, superannuation becomes a national employment standard. So for the accountants in the room, what that means is that in addition to the powers that the Australian Taxation has in relation to the superannuation guarantee, the Fair Work Ombudsman can now also prosecute it as an underpayment of wages and as a component of wage theft when that comes in. Work and Care review of modern awards was launched following a Senate committee review into work and care. They made a number of recommendations, and the Commission's now been charged at looking at how those things can be dealt with in modern awards, and they do include stuff around reducing working hours. They potentially could result in looking at 4-day fortnights or 36-hour weeks, etc. February 2024, the test for misrepresenting employment as independent contractor changed to what employer reasonably believes. So under the former government, the emphasis was very much on what the contract said. And if it said it was an independent contractor, then so be it. What this is saying is that it's having regard to the broader relationship there might be, and then what employer would reasonably believe to be true based on those broader considerations. Work value case for nurses and midwives started at the Fair Work Commission, and expect one with childcare workers to follow. Workplace Gender Equality Agency published gender pay gaps for the first time. So businesses with 100 or more employees have to lodge a return with the Workplace Gender Equality Agency on their pay data broken down by gender and level and etc. So those have been published for the first time, and civil penalties under the Fair Work are increased 5-fold. So they're very expensive. We have another wage review coming up. 1st of July, I'd expect it to be somewhere in the realm of 3.5% to 4.5% this time round. The Fair Work Commission is able to deal with unfair contract disputes for independent contractors. There are unfair contract jurisdictions in some other state legal systems, but haven't been in Victoria, so this is a federal one that's been introduced. New definitions of employee, full-time, part-time, casual coming along, new rules on casual engagement conversion. So under the Morrison government, the emphasis was very much on what the contract said, and there not being a continuing guarantee or guarantee of continuing employment. What this is now saying is returning to the broader test on whether or not, when you look at the totality of a relationship, it really is casual engagement, or it is more like full-time or part-time employment. There are changes to the conversion stuff, but there's not really anybody better off either way. The new Fair Work Commission jurisdiction. So we now got gig workers hired on electronic platforms and independent contractors in the road transport industry. And the Fair Work Commission will be able to set minimum standards and protections. There'll be enterprise bargaining arrangements, unfair contracts, jurisdictions, and unfair terminations where somebody might be deregistered from a platform. Employees with employers of 15 plus employees get right to disconnect outside contracted hours. So this is probably not that much of an issue for most businesses because, to be honest, it doesn't stop an employer or a manager from emailing somebody, for example, out of hours. It just means that the employee doesn't have to respond. And you can do things like schedule emails for 8 o'clock the next morning, which can get around this as well. There may just be some issues for businesses which maybe operate across different time zones. It's one of those things where the best thing is probably to educate all your people and to sit down and talk about it and put the right protocols in place. And the final lot, in November 2024, the regulated labour hire orders take effect. So that's the stuff around same pay, same job for labour hire workers. Won't affect 95% of businesses. Wage theft becomes a criminal offence, and that includes imprisonment for up to 10 years. And if you look at the Commonwealth Bank, for example, who were recently fined $10.34 million for underpayment of wages, and where the judge said that they knew that they were underpaying people and they continued to do it. So arguably that could be viewed as wage theft because they did it knowingly, according to the judge. There was also a horrible case of a massage parlour operator in Canberra that's just recently reported where he was ripping off Filipino migrants and threatening them with killing their families if they didn't comply. So that would definitely be a candidate for wage theft and probably should be a criminal prosecution anyway. And there's a voluntary small business compliance code coming in that businesses can sign off on, and that will then mean that they will be exempt from prosecution for wage theft. But I want to emphasise that to be guilty of wage theft, you have to be really naughty. You have to, if you just make a mistake, you're not going to be prosecuted for wage theft. There's another annual review next year, and then employees with employers of less than 15 employees get a right to disconnect outside contracted hours. There will no doubt be more to come. For example, there is stuff going on in the ACCC around the enforceability and validity of restraint of trade clauses in employment contracts. So we might see something coming in that space, and no doubt there'll be more from the federal government to come. So, look, that's been a huge information dump that I've laid on you, and I hope that it has been helpful. So now we'll have a little talk about what we might do. And I want to ask you a question. Do you want to develop a positive culture in your business? Do you want to be a good employer? Do you want to have a positive mindset? Because that's what people want. And if you adopt that attitude, most of that stuff isn't going to be a problem for you. This is our very simple and practical compliance model, which we developed some 15 years ago. In essence, there are four elements to it. The first is that there's a commitment, and that is that I genuinely commit to the fact that I want to be a good employer. I want to comply with all my obligations. I'm going to go and find out what I need to do, and I'm going to commit to doing it. The second is that I then invest in the capability, which is that I build the systems, the processes, the tools. I invest in the people, and I invest the time to make this work and to give life to that commitment. I then train the people who are involved in the parts they have to play so that they can utilise that capability in the right way to get good outcomes. And then the culture piece is around having that happen on an everyday basis where it's embedded in everyday behaviour and practice in the organisation. And you need to do all of those things to be truly compliant. What I know is that most organisations I go to, there's a bit of capability. They've done something. They might have some policies and stuff. They might have done a bit of training. They really haven't made a commitment because they've just gone through a process here of putting in a policy and telling people about it. And it's not embedded in culture because there isn't any drive to actually make it all happen consistently. So all of those things need to happen. What's a positive duty? You have to take positive action to understand and address your obligations as a person conducting a business or undertaking. So it's under workplace health and safety laws, and it applies whether or not you have employees. It's that you're operating a business or undertaking. Eliminate risks arising from psychosocial hazards. If you can't eliminate a risk, minimise the effects. Implement, maintain and review control measures, and consult. The Safe Work Australia model has consult written around every part of the process, so it's important to do. Psychosocial hazards are hazards that arise from or in relation to the design or management of work, the working environment, planted at workplace interactions or behaviours, and may cause psychological and physical harm. Now, I'm not going to go into them in detail today. There are 14 of them. We will do that in a separate workshop. Now, the other thing you need to do with this is look at it through 4 lenses. So, and the 4 lenses are, firstly, our policies. So are the settings we've got in our policies, is the language used in our policies, is the content in our policies, does any of that, contrary to what we might want to be saying in the area of psychosocial hazards, etc. Are our work processes clear? Are there points of conflict in them? Is the way that we manage people issues, are those processes ones that are supportive or ones that are judgmental and potentially harmful? With our day-to-day practices, with the conversations that happen around the office, with the way we do stuff with customers or the interactions that there might be, with all of that stuff, are there any issues there? And with our people, we all know that we have people who are probably more risky in their behaviour than others when it comes to sexual innuendo, or maybe they're micromanagers, or maybe they're bullies, and we need to address them through that lens as well. We developed a framework for addressing the positive duty, and there are essentially 5 stages in it, and it's called the HEART model. First step is honesty, and honesty is twofold. It's around, going and finding out what you need to do rather than putting your hand in the sand. And secondly, taking a good hard look at your policies, processes, practices and people. Engagement is about educating your people, get them to understand what the requirements are and the role that they need to play, and engage them in consultation, collaboration and co-design. I'm always amazed at the number of organisations that don't seem to understand that every person that walks in with a life full of experiences and knowledge and connections and ideas, and that can all be drawn on. So there's great value in engaging with people and tapping into that resource. Accountability is about putting processes and systems in place and being a role model, showing, leading the way and holding everyone accountable without exception. Review, this is a continuous journey. It's not a transaction. So we need to continue to monitor and measure progress, and we need to continue to learn and seek and celebrate improvements. And trust is about being vulnerable, really listening to your people and letting them know that you're listening to them so that they come to trust you, and building psychological safety for everyone. The ways in which we can help in each of these steps, we can run training, or we can do deep dives into your organisations to identify what the positives and opportunities for improvement are. We can educate your people. We facilitate better workplace teams, workplace improvement teams, consultative committees, whatever you want to call them. We can help with that. We can design the policies, processes and systems you need in the right language, and help you to be a role model, and that can be in coaching you on how to do that, and also supporting you when you need to hold people accountable. You need to continue to monitor and measure progress, and one of the things we can do, there are survey tools that we use, for example, that can periodically measure the state of psychosocial hazards and workplace wellbeing, and continue to learn and celebrate improvements, so we can help you with that as well. And building trust. So what we try to do is to become a trusted advisor to you and your people, so that they feel comfortable coming to us as well. Now, going on to the next one, this is going to be on understanding the Fair Work system and the players. It is complicated, and what we aim to do with that is to help you to be able to know who does what and where to go for what, what's important and what's not. And then obviously we have the other 5 sessions to come after that. So that pretty well wraps up today. I realise that there's been a huge information dump in this. If anybody has any questions, feel free to give us a call. Happy to have a free, no obligation conversation about anything that resonated or that you have questions about today. And thanks for coming along, and we hope to see you next time. And on that note, we'll say goodbye.